All right, hello everyone. Welcome in. See, people are still joining, so we'll start in about a minute. All right, it is noon. We'll go ahead and get started. Good afternoon, everyone. My name is Vanna Shaw. I'm a legal services staff attorney, a Young Friends board member, and the moderator for today's CLE. Today's CLE is on immigration. A little bit about legal services. Legal Services of Eastern Missouri advances justice through legal representation, education, and supportive services. We partner with the community to improve lives, promote fairness, and create opportunity for those in need. You can learn more about us and our services at lsem.org. And just a quick note, we are also celebrating 70 years of service this year. So a big milestone. Today's presentation covers immigration law, including an overview for those not familiar with this area of law, administration changes concerning immigration, and topics affecting employers. This program has been approved for one CLE credit hour, and we will monitor the chat for questions. At the end, we'll take a few questions as well. So drop those in the chat, or we may pull yours at the end if there's time remaining. We have two amazing speakers today. First, Amanda Williams, and after her, Mollie Hennessee. I'll go ahead and introduce Amanda now. Amanda Williams is a senior staff attorney with Legal Services. She has been educating lawyers and the community at large on immigration for the past 5 years. The program here, Legal Services, assists those wanting to become naturalized citizens, apply for relatives to join them in the United States, or apply for benefits. Amanda will cover a firm grasp of immigration fundamentals in the United States so we can clearly understand what is going on in the news and our own communities. Amanda.
One second. We did this, right? Okay. All right, perfect. Hi, everyone. My name is Amanda Williams. I'm an attorney, a senior staff attorney at Legal Services in the Immigration Department. I've been there for about 8 years. I've been practicing immigration law for over 20. I started doing these type of presentations about 5 years ago because first people asked for them because immigration is all over the news and people wanted more information. And second, because I was realizing that with it being in the news so much, people had opinions and people had comments and chats on the internet, and so much of the comments and what was said was misinformation. So I just wanted to give people a very basic understanding of immigration law so they can go and find out more or just have more, I guess, informed conversations about it. And I also do the same presentations for lawyers and legal professionals because, 20 years ago when I was handed my first immigration case, I knew nothing about immigration, absolutely nothing. And so it was kind of trial by fire. So I figure, I didn't learn anything in law school about immigration. If you don't practice it, you probably didn't either. So this is going to cover how one obtains legal status in the United States and then possibly becomes a citizen. I always like to think in kind of pictures in my head, and I think the United States opens the door very, very, um, very small. They open it just a little creek to let people in. And I'm going to explain that small amount of people who are allowed in and able to live here permanently. So we will start out with visas. What is a visa? It's an endorsement, a passport that allows a foreign national to seek entrance into the United States. There's two types of visas, immigrant and non-immigrant. So, immigrant visas are given to people who intend to live permanently here in the United States. Non-immigrant visas are for people that are going to only be here for a short amount of time. Um, so the types of immigrant visas, the people who are going to stay here permanently, and these are the four categories that if you know nothing or remember nothing from this, maybe remember this. These are the four categories of people that are allowed to come into the United States and apply for permanent residency and then possibly eventually citizenship. So many people have, misconceptions about who's allowed in and who's not. And like I said, it's a very small amount of people. So there's family sponsored, the visa lottery, which isn't happening right now under this administration, certain humanitarian visas, and employer sponsored, which Molly will talk about the employer side. I'll talk about humanitarian and family sponsored the most. I do a lot of humanitarian visas here at Legal Services. Examples of non-immigrant visas, exactly what you think of: business, tourism, students, fiance, the 90-day fiance, athletes, artists, entertainers. So let's start with family. Only certain family members are you allowed to petition for if you are a citizen or legal permanent resident. You can't petition for your cousin or a niece or nephew. So the first category of family-based petitions, immediate relatives of U.S. citizens, like spouses, unmarried kids under 21, a parent at least 21, which doesn't make a lot of sense that they put that in there, but you have to be 21 to um, petition for someone, but it's there. Other relatives of U.S. citizens, unmarried children over 21, a married child, a sibling at least 21. And then if you're a relative of a green card holder, these are the people you can petition for: a spouse, an unmarried child under 21, or an unmarried child. So, what do you do? So your family member petitions for you. They file what's called an I-130, which is just an application that proves the relationship between you and your family member in the other country. So it's a very long process, but you have the person in the other country gets a visa interview. You know, hopefully they pass through the interview, they obtain a green card, and then they wait 3 to 5 years, continue to reside in the United States. And then after that, 3 years for a spouse, 5 years usually for everyone else, then they can apply for naturalization. Another group of people who are um, allowed legal permanent residency visas and then legal permanent residency to come here, I will put under the humanitarian category, but they're mostly on their own in my mind. They're refugees and asylees. Refugees and asylees are asking to be let into the United States for the exact same reason. They must prove a well-founded fear of persecution due to race, religion, nationality, political opinion, or membership in a particular group. So again, I think of a picture in my mind, what makes them different. Asylees are at a port of entry, a border. And in my mind, they're knocking on the door and say, I'm at the border, let me in. Because I have this well-founded fear. And so they're there. That's where they are, border, port of entry. Refugees are in other countries and they're asking the same thing, but they're not near the United States. And refugees go through a different process. They both, asylees and refugees, have to go through a lot of background checks and screening. But refugees, it usually goes through the United Nations, and then they're resettled here in the United States. And usually, the place where they're resettled is picked for them. Of course, asylees, if they're let in, they can go wherever they want. They're not resettled. So when you're a refugee and asylee and you're finally granted refugee status or asylee status, what happens? You apply, so you're in the United States, you apply to obtain a green card after 1 year. Once you get that, you wait 5 years with continuous residence in the United States, and then you apply for naturalization. Another very important humanitarian visa that I personally do a lot of at legal services, it's called VAWA relief. The Violence Against Women's Act has a part in it that says that you can apply for this protection and this relief and eventually get permanent residence and maybe citizenship. So the problem why this was written into the Violence Against Women Act is family-based petitions require U.S. citizens and LPRs to apply on behalf of their non-citizen relative. So, for example, just to make this up, I'm here in the United States. I have a family member in France. I have to apply for them. I have to petition for them. Or say I'm married to someone who is not a citizen or LPR, I have to petition for them. However, if I'm an abuser or someone is an abuser, they can use this process to control and oppress the person they are petitioning for. I've seen it over and over again. People, the abusing spouse, uses the petition process as a way to manipulate and really harm their spouse by saying, do X, Y, and Z. If you don't, I won't apply for you. Or they use it as a punishment. They use it as a carrot that you never get to that point of them petitioning for you because they're abusive and use it as manipulation. So, what's the solution? VAWA applicants can attain their green cards without their abuser's knowledge, consent, or participation. Spouses, parents, and children of abusive U.S. citizens or LPRs can do this. The benefit, they obtain legal permanent residence and eventual citizenship without relying on abusive family members. It takes a really long time for this process to go through all the steps. What I do as the attorney for these abuse victims is, I gather all the information and we spend a lot of times, we have to prove the abuse. And a lot of times it's not clear cut. Sometimes I'll have lots of medical records. That's great. But sometimes it's emotional abuse, psychological abuse. How do you prove that? You do a lot of affidavits. You get psychiatric records. You have the person start to go to a counselor, get those records. So it takes a lot of time of gathering information. I've just had a couple cases that were approved for VAWA recently, and I applied for them 6 years ago. So that's how long it can take, 5, 6 years just to get VAWA approval. And they haven't got their green cards yet. That's just the VAWA approval. So it takes a long time. The next category of humanitarian relief, which I do a lot also, are U visas. These are granted to immigrant survivors of crime. It offers legal protection to immigrants who help with investigations and with the prosecution of their cases. Why this law was written really is to encourage immigrant survivors to report crimes to law enforcement. This, like VAWA and like other humanitarian visas, offers a pathway to citizenship. You have to be a victim of a qualifying criminal activity. There's a list of different crimes that apply here. Not everyone applies. You have to suffer substantial physical or mental abuse as a result of this criminal activity. You have to have information about the criminal activity. And the biggest thing is you have to be helpful or likely to be helpful to the police. And the crime has to occur in the United States. What is a big thing about this is you have to be helpful to the police, and the police or prosecutors have to fill out a form that says, yes, you were helpful. And sometimes it takes them forever to do that. Sometimes they refuse. There's nothing in the law that says they have to do this. So it's a lot of us asking nicely, waiting, and I've never had a problem with police or prosecutors not doing it eventually, but I have had to wait significant amounts of time just to get that paperwork. T visas, another um, humanitarian visa. T stands for trafficking, allows survivors of human trafficking and their immediate family to live and work in the U.S. on a temporary basis, provides a pathway to legal permanent residence and citizenship. It's desirable for the applicant to help law enforcement, just like U visas, but it's not required. They don't have to. They have to be a victim of severe forms of trafficking or physically present in the U.S. due to trafficking. And remember, trafficking is either labor trafficking or sex trafficking, and usually they kind of intersect. It just means forced work, forced sex. So someone is, forcing you, a group of people who don't have any documentation to do work or to engage in sexual activity, it can be considered trafficking. I do T visas also legal services, but not nearly as much as U visas or VAWA. So, to go back, we learn the four categories of people that can get legal permanent residence, possibly. People who have a family-based petition, humanitarian visas, the visa lottery winners, which, like I said, isn't going on right now in this administration, and then some people um, who have employer-sponsored visas. So, once everyone has those visas from those different categories, what happens next? Well, they apply for legal permanent residency, which is, colloquially called green card. That's what it looks like. When I first started, it was just shows how long ago it was. It was paper and didn't look anything like this, and it was all just green. So that's where, the name comes from. So, what does permanent residence get me if I'm applying? What does a green card do? It allows you to live and work permanently in the United States. So, I am a US citizen, born here. Someone with a green card has almost all the same rights I do, except they cannot vote and they cannot have extended absences, usually over a year, and no serious criminal conduct. Now, if I had extended absences or serious criminal conduct, you know, I might be in trouble for the criminal conduct, but, I wouldn't be deported because I'm a US citizen born here. And green card holders, they have all the same rights, like I said, as I do, but they have to watch out. Don't leave for over a year, stay out of trouble, and don't vote. And otherwise, you can have your green card for the rest of your life here. You don't ever have to apply for citizenship. And you can just have your green card and just renew it every 10 years if that's what you want to do. So we already talked about this, but who can become a legal permanent resident, refugees, asylees, and beneficiaries of approved immigrant visa petitions, the family-based, humanitarian-based, employer-based. So I am applying for someone's green card. What do? I have to show their eligibility was established. They have an approved visa petition. Then we do the green card application. If they're inside the United States, we call it adjusting status and we work through USCIS. If they're outside of the United States, it's called consular processing. And we deal with the State Department, the National Visa Center. So make the application. First thing that happens is they usually get biometrics equipment, which is just fingerprints, the interview, and then you receive a decision. Now, all of that seems a lot quicker than it is, but that's just the general way it goes. So, the naturalization process. Like I said, you can have your green card for the rest of your life. You don't ever have to become a citizen. But a lot of people do for personal reasons, professional reasons. Um, Sometimes it's because they want to vote. Sometimes it's because there's certain retirement benefits or disability benefits in their state that's only given to citizens. So a lot of different reasons, but 3 years if you're married to a citizen, after 3 years, 3 years with a green card, you can apply for citizenship. 5 years, mostly everyone else. And so someone comes to me and they want to become a citizen. What do I discuss with them? Well, like I said, legal permanent resident for 5 years, 3 years of marriage to a U.S. citizen. You have to show continuous residence and physical presence in the United States. You have to pass an English and U.S. history test at the interview. Um, People 65 and older can take a mod and who have been here for 20 years can take a modified version. People with disabilities, it can be waived, but you have to show that their disability prevents them from learning English or history. That's very, very important. So their disability has to affect their learning of these things. It's just not any disability that's severe. We have to show that a person has good moral character and that they're willing to take an oath of allegiance. So, what is continuous residence and physical presence? Reside here for at least 5 years as an LPR. Be physically present in the US for at least half of those 5 years. Live in the district where you're applying for at least 3 months. And so the big thing out of this is I tell my green card holder clients, if you eventually want to apply for citizenship, do not leave the country for more than 6 months because if you at a time, because if you do, um, you can apply for citizenship and so, say your 5 years is up, you've waited 5 years and you're ready to apply, but I go back and look in their passports and I see that they're gone for 6 months or longer. So, the date that they come back is the day we start the 5 years all over again. So, that's something big. I tell people do not leave, please, for over 6 months. That's spoken about here. So, I see that they have continuous presence and residence. Next, we go to good moral character, and this is probably the trickiest, most confusing part of the naturalization process. So we look at kind of a look back period. Behavior within 5 years before the N-400, that's the naturalization application, is filed that prevents client from demonstrating good moral character. These are the things. A conviction for a crime of moral turpitude. If you practice criminal law, you know what a crime of moral turpitude is. Immigration law, it's not anything like that. Congress decides what a crime of moral turpitude is. So some things that you would think are crimes of moral turpitude, definitely on there. But some things that definitely you would never think were crimes of moral turpitude. I remember reading about someone, gosh, this was a case a while back, had to do, and I wish I had the specifics, but I can't remember. It had to do something with um not coming for jury duty, something about jury duty. And Congress decided that that was a crime of moral turpitude. So it's just whatever Congress, when they wrote these laws, said, oh, that's a crime of moral turpitude. So you can't have a conviction for a crime of moral turpitude. You cannot have two or more offenses, which with aggregate sentences of 5 or more years. You could not violate any controlled substance law except one offense for simple possession of less than 30 grams of pot. If you're actually confined to a penal institution for 100 days in aggregate, no. You ever gave false testimony under oath? No. And then this last one just shows how immigration law has not been updated, changed, and the things that need changed Congress can't get together and do it because we have things like this still in the law. If you are involved in prostitution, smuggling, polygamy, conviction of two or more illegal gambling offenses, or are a habitual drunkard, that shows that you do not have good moral character and can't apply for naturalization. This leaves so many questions in our heads, right? Habitual drunkard. How are they going to find that out? And if they do, how do they prove it? Two or more illegal gambling offenses, really, that's not good moral character when someone else does something that people may think is more severe. They could have good moral character. So these are things that are obviously based in another time period in the early 1900s, um, and just hasn't been changed. So I'm with the client and I say, okay, you have the continuous residence and presence. You have good moral character, at least what I assess with all these things. Let's talk next about the naturalization test. So, first, you have to show that you can read, write, and speak English. Does this mean that you have to be native born English speaker, perfectly fluent? No, but you have to be able to read aloud one of three sentences correctly, write out one of these three sentences correctly, and then the USCIS officer will determine your ability to speak English during the eligibility interview. So that's usually not the part that freaks people out. What makes people very nervous is the US History and Civics exam. It's an oral test. Version just changed with this new administration. Instead of the 10 questions people were asked before, they're now asked 20 from a list of 128 questions. They have to get 12 of them right. Like I said, there are some exceptions for age and for disability, but they're not automatically given for disability. So remember that. Also, people have to be willing to take the oath of allegiance, be loyal to the U.S., follow our laws. The one that kind of trips people up is willing to bear arms on behalf of the United States. You have to say yes. So that's the oath. So in the last couple of minutes, I'm going to talk about some things you hear a lot about in the news and kind of explain it a little bit. It's going to have to be a little fast because I only have a few minutes left, but these are important things to know. So everything I just talked about, those four categories, green cards, then legal permanent residence. That's the basics. Who can come in? Who is allowed to apply for green cards? How that process goes, and then naturalization. So there are other things we hear about though. And the first one is DACA. That protects certain undocumented immigrants who came to the US as kids. Lots of rules about it. Arrived in the US before turning 16, continuous residence since 2007. Um, the thing is, DACA does not give you a pathway to a green card or citizenship. And right now, they're not taking any new DACA applications. They're renewing DACA, but it's in the courts right now. The courts are deciding if it's constitutional. Some recent policy changes to immigration. I'll go through these pretty quick. Um, but just maybe make a note to yourself if it's something that you want to ask me later or you want to look up yourself. So of course, there are lots of executive orders at the beginning of 2025, the birthright citizenship question, which it was now the Supreme Court's deciding that, so we're waiting on a decision with that. Trump signed an executive order suspending asylum access at the southern border. That's being decided in the courts right now. The refugee program has been suspended. No new refugees are being resettled in the United States. Federal appeals court ruled last March that the president can partially enforce the refugee ban, blocking federal funding for sanctuary cities. That is that was questioned in the courts, and a judge said that did violate the Constitution. So temporary is protected status is another um, kind of topic, or I'm sorry, another status that grants people from countries experiencing crises temporary status, but they do not get any pathway to citizenship at all. So it provides people temporary protection from deportation and temporary work authorization. Um, you get it 18 months at a time. Doesn't provide a path to lawful permanent residence. And the president usually decides um, what countries should have temporary protected status, usually places with horrible earthquakes, floods, war, things like that. But just remember, people with TPS don't get green cards. Um, Recently, Venezuela's designation was terminated. Haiti and Syria, that will be decided. It says 2006. I meant 2026. So that was heard by the Supreme Court recently. And the last thing, I've got, about 30 seconds. This is the biggest thing that's probably affecting me in my practice right now. Recent travel bans. So back in 2025, Trump announced that there's travel bans for all of these countries affected. And that means not only can these people not travel to the United States, if people are from these countries and they're applying for, say, green cards, right now all their applications are suspended. So I have people whose family members passed the visa interview and were waiting for visas, and they've waited like, years and years for this. But now there's a travel ban, so they can't come here. Some of my clients from Afghanistan are applying for green cards, but USCIS is not doing anything with their applications because the travel ban. The government's decided if you are from a country on this list, we're not touching anything that has to do with any of your cases right now. So, and then there's been a lot of stuff with ICE policy shifts. We've seen more arrests, ICE going to schools and churches and places like that. Bond hearings were eliminated. Um, that was a decision. A decision was made in a federal lawsuit that says bond hearings have to be allowed. It doesn't mean you get bond, but you have to have the hearing. So I went through that last part pretty quick. But to take away from that, just know that DACA TPS, no pathway to citizenship. And there's now a 75 country ban. So those people from those 75 countries, nothing's happening with their cases right now. So that's probably some of the biggest things we're dealing with. And right there, you can see my email. If you have any questions, a personal question about immigration, something, you're dealing with a client, please email me. I don't mind answering questions or talking to people. Obviously I can't give advice, but I can tell you where to look or give you some information. I love this topic. I love immigration and I love learning from other people and sharing what I know. So I thank you all so very much for coming to this.
Okay, well, thank you, Amanda, so much. I do see one question, so I'll save that for you at the end. Now we're going to go ahead and switch to Mollie Hennessee. Mollie is an immigration attorney at Thompson Coburn. She has extensive knowledge and diverse experiences working in the increasingly complex U.S. immigration system that allows her to effectively guide employers and their foreign national employees in securing temporary and permanent immigration status, work authorization, and U.S. citizenship. She will cover employment-based sponsorship, including immigration visa categories, the labor certification process, and common non-immigrant worker options used by employers. Go ahead, Molly. You're muted currently. So we can see your screen. We just need you to unmute at the bottom.
Sorry, technical difficulties. Can you guys see the screen and we're all good?
Yep, we can hear you and see you. Thanks.
Wonderful. All right. Thanks so much, Vanna and Amanda, and hello to all of you. So now that Amanda has given us a really helpful overview of the various pathways and statuses, I'm going to do a little bit of a deeper dive on business immigration and the things that are going on in that space right now. So let's dive right in. Okay, so here's just a quick agenda of what we're going to cover. This first item I'm going to brush over pretty quickly because Amanda already talked a little bit about the differences between non-immigrant and immigrant status. Then we're going to kind of break it down into two sections, talk a little bit about non-immigrant statuses based on employment, and then we'll talk about the immigrant classifications based on employment. So that's people who can get their green cards based on employer sponsorship. And then if we have time at the end, I'm going to talk about some recent trends and changes in business immigration. So a lot to cover here. Okay, so this just kind of gives an overview of what Amanda just talked about. So a lot of the different ways that you can come to the United States. Like I said, we're going to be really focusing on employment here for the last half of the CLE. Okay, so non-immigrant versus immigrant status. Just kind of a refresher, a reminder, your non-immigrant statuses, those are going to be temporary. Somebody is able to come into the United States for a set period of time and for a set purpose. So they're coming to visit, they're coming to attend school, they're coming to work temporarily. That's all of your non-immigrant statuses, whereas the immigrant ones are more permanent. So mostly, Amanda talked a little bit about some of the situations where somebody's green card can be taken away, but there's no set time. You can have a green card for as long as possible, as long as none of those issues arise. So criminal, or you abandon it by being outside of the US for so long. Okay. Okay, so diving in a little bit on the various non-immigrant visas. They are identified by letters, so kind of like an alphabet soup. I feel like if you hear an immigration attorney talking, sometimes you're like, what are you saying? Because there's so many letters and abbreviations, but that's what is used to identify the various non-immigrant statuses. So there's a whole bunch of them. I'm not going to talk about all of them, but I've highlighted on this first slide the most common work-related non-immigrant statuses. So there's several that are based on the nationality and citizenship of the individual. So there's this E3, which is available for specialty occupation workers from Australia. Similarly, there's an H1B1, which is available for people from Singapore or Chile. Both of those are specialty occupation visas, which is similar to the H-1B, which I'm going to talk about here in a little bit, and I'll explain what that means. There's also H-2A and H-2B visas, and that's going to be for your temporary seasonal work. So the H-2A is agricultural, so like field workers, people who are coming in to do harvesting. And then the H-2B is non-agricultural. So that's going to be like hospitality workers, perhaps, or landscaping. That's the type of visa that they would use. Now, all of these require a U.S. employer sponsor. So that's a really key point. It's not that somebody from another country, a foreign national, can go and get these on their own. They have to have an employer that is willing to sponsor them. Okay, so the two that I'm going to spend a little more time talking about are ones that I handle regularly in my practice and come up quite frequently for employers who have foreign national workers. So the first one is the H-1B visa, or the H-1B status. And this is probably one that you guys may have some familiarity with. You may have heard about it in the news, just because there's been a lot of change in recent years dealing with H-1Bs, and they're kind of a hot topic in the media. So, but to get an H-1B, you have to be in a specialty occupation. That is a defined term that essentially means that somebody has to have a college degree or the equivalent of that in the field of specialty required for the position at issue. So there's that's kind of the basic level requirement for the H-1B status. There's also a lot of employer obligations that come with sponsoring somebody for an H-1B. In particular, they have to agree to pay the prevailing wage for the location where that person is going to work. So there's a process for determining what the prevailing wage is, but that's one of the requirements that employers have to agree to as part of sponsoring somebody for an H-1B visa. There are a limited number of H-1B visas available each fiscal year, and because demand exceeds the supply, the government uses a lottery process to select who gets H-1B visas each year. So the way that works is employers who have a foreign national person who they want to sponsor for an H-1B, they have to register for the lottery in March. It is then run by the government, and they notify all the people who were selected as part of that lottery. And then the employer has to file a petition where USCIS, U.S. Citizenship and Immigration Services, reviews and makes sure the person meets the qualifications for that status. And if approved, they can start the job October 1st of that fiscal year. So it's a bit of a longer process. It requires advanced planning by the employers. It's generally not something where they can just find an employee and say, okay, we want to get them an H-1B, and they're going to be able to start working in a month or two. It's going to take a while to go through that process, and there's no guarantee that they will get selected in the lottery. There are cap exempt employers, so people who are not subject to that limitation for the number of H-1Bs available each year. And it's mostly like colleges and universities and other organizations that are affiliated or associated with colleges and universities. So they're not subject to that limitation. They don't have to do the lottery process. They can just file the H-1B visa, but it is an issue for most employers. There is also a limitation on how long an individual can be in H-1B status. So in total, they can be in that visa status for 6 years. There is the possibility of extending it beyond the 6 years if they are currently under the PERM process or in the process of having an employer sponsor them for a more permanent visa. So that is an option there. Okay. Next, I'm going to talk a little bit about L1 visas, and that is a visa that is available for multinational companies that have kind of entities, affiliates, subsidiaries all over the world. So when they have an entity abroad and they want to bring an employee to the U.S. to work for their U.S. location, they would use the L1 visa. So there's two types. There's the L1A, which is available for executives and managers. So that's going to be people who are managing other professionals. It can't be a first line supervisor or managing an important function or division of the company. So those folks would come in on the L1A. They do have to have worked for the entity abroad for at least a year in the last 3 years for both of these subcategories. And then the second one's the L1B, and that's for specialized knowledge workers. So those are people who have, and that's a defined term. It can be difficult to establish, but it's for folks that have like a particular knowledge, perhaps in their industry or for that company, that isn't easily found in U.S. workers or from people who are outside of the company. So as a little bit of an example, that might be, we've had like field engineers or technicians or people who have worked at like the manufacturing facility for a company abroad for, 10 years. And they have this like really unique knowledge and specialized knowledge about how to service that equipment. So they need to come to the US to service the equipment for the US customers. That would be an example of an L1B specialized knowledge visa. There are time limits for these as well. It's 7 years for L1As and 5 years for L1Bs. And I feel like I'm talking too much, so I'm going to go ahead and move on. Here's a few other non-immigrant visas that are based on work on somebody's employment. There's the O1. There's 2 subsections for that, but this is a pretty high level visa available for people who are at the very top of their field. So you have to show extraordinary ability or extraordinary achievement. They're document heavy filings. It's a high standard, so tough to get, but it is possible. There's Ps, which I think Amanda had mentioned. There's Rs, which are for religious workers, and then there's TNs, which is another one that we see somewhat regularly. And this classification is limited to people who are Canadian or Mexican nationals. It's part of what used to be called NAFTA, now called the US-Mexico-Canada Agreement. But as part of that agreement, there's a whole list of occupations and requirements for people who are Canadian or Mexican who can come to the US to work in those professions. So accountants, engineers, librarians, social workers, I think lawyers is on the list. There's a whole bunch. So that's an option for folks from Canada and Mexico. Okay, and then this is the most common non-work related non-immigrant visas, which Amanda already touched on, so I'm just gonna move forward. Okay, so the non-immigrant visa process. So the process to get those non-immigrant visas or that non-immigrant status is sort of dependent on the classification at issue. For many classifications, particularly ones that are employment-based, so your H-1Bs, your L-1s, your O-1s, you're first going to have to file a petition with U.S. Citizenship and Immigration Services, who reviews that petition and confirms that the individual and the job at issue meets the requirements for that category. And then if approved, the person would then apply for the visa at a consulate abroad. And that visa, which is like a stamp that goes, a foil that goes in their passport, is what allows them to enter the United States in that status. Other classifications like B1s, B2s, so those are visitors, students, F1s, TNs, they can apply directly for the status at the US consulate or abroad, and in some cases at the border. So it just sort of depends on what you're seeking. Once in the US, there is the option of both extending or changing your non-immigrant status. So somebody who comes in, say, on an H-1B, and they're given 3 years for they're able to stay for 3 years, they can file an extension of status, assuming their employer still wants to sponsor them, to extend that time. Or if somebody is, say, in F1 status going to school and they graduate and find a job and their employer wants to sponsor them for an H-1B or a TN or some other, they can also file to change status within the US without having to leave the US, depart and then return in a different status. The key thing to remember for that is that they have to be eligible for either an extension or a change of status, they have to have maintained status. There can be no gaps. So anybody who maybe came a long time ago as a child and hasn't had status for many years, they're not going to be able to switch or change to a non-immigrant status within the US. They're not going to be eligible for that. And then the last bullet I've got here is the impact of travel abroad. And that's just something that needs to be considered. It's becoming increasingly risky to travel abroad, whether for work or to visit family, if you're planning to return to the US in your non-immigrant status. And that's because issues can arise while people are abroad that may prevent or delay their return. And we're seeing that a lot. Amanda mentioned the travel bans, that could be an issue. In the fall, there was a new proclamation issued about a really significant $100,000 fee for H-1B visa holders. And so we had a lot of clients who were scrambling to get back to the US when that came out, because they were abroad for work or visiting family or whatever it may be, and they didn't want that fee to apply to them. And it was unexpected. Nobody knew that was coming out. So people traveling abroad just have to be really thoughtful and careful and work closely with their immigration counsel to make sure there won't be any issues that arise. Okay, so now I'm going to talk a little bit about the employment-based immigrant categories. So we just covered non-immigrant, that's the temporary ones. And now I'm going to cover the pathway to a green card through your employment. So up here on this chart, we've got a list of all of the different categories. I'm not really going to discuss EB-4s and EB-5s because they're not super common, but those are options. They're special. The EB-4s are for certain special immigrants. So like former government employees, translators, there's a whole bunch of list of special immigrants that would fall under that category. And then we also have the EB-5 investors, and those are people who are willing to invest a large sum of money into a job creating enterprise in the US, and that can provide them with a pathway to a green card. So not going to really talk about those. What I'm really going to talk about is these top three. The first one, the EB-1, is a priority worker category. That is broken down into 3 subsets. So the first one is these persons of extraordinary ability in the arts, science, education, business, or athletics. And this is kind of the immigrant or the more permanent counterpart to the O1 that I was discussing earlier. Again, it's increasingly difficult to get this category. It's a document heavy filing, just like the O1, and probably even more, more difficult to get than the O1. You really do have to show that this person has risen to the very top of their field, whatever that may be. So you do that through showing like national awards or news media about their work or professional publications or perhaps patents. It sort of depends on what industry they're in. But just to give you guys a little bit of context, only about 46% of those applications were approved in the second half of last year, which was down from 70% in the first half of last year. So just receiving a lot of scrutiny right now, a tough one to get. The second category here for EB1 is for outstanding professors and researchers. And that's going to be folks who are tenured or tenure tracked and they're working at universities. And you just have to establish that they have a strong academic publication record, that they're engaging in peer review. There's very detailed requirements for what you have to show, but that's who's going to qualify for that second category. And then this last EB1 category is for multinational managers and executives. And that is going to be the immigrant counterpart to the L1A visa that I was discussing earlier. So this is just the way that those individuals would be able to stay more permanently. So all of the EB1 categories do not require what we call perm sponsorship, which I'm going to talk a little bit more about here in a second. But so it's a more simplified process. So for the EB1 category, they have to file an I-140 petition with USCIS. And if that's approved, they can then seek to adjust status and get their green card. For these EB2 and EB3 categories, with the exception of the national interest waiver, those do have to go through the perm process. So this is a process that's run by the Department of Labor, and the purpose is to test the labor market and ensure that there are no qualified U.S. workers that are available for the positions at issue. It's a long and somewhat arcane process that doesn't really reflect how employers actually recruit and hire their workers, but it's what we've got, and so it's what we work with. The different categories or levels here within the EB2 and EB3 sections are really based on the individual's education background. So do they have an advanced degree? If so, they would be in the EB2 category. Or if it's just a bachelor's, they would be a professional. That's in the EB3. Skilled workers have at least 2 years of training or experience, and then the unskilled workers have none of that. So it's really just broken down by education and years of experience. One thing to note before I advance to the next slide is that there are a limited number of visas available each fiscal year for these categories. So because of that, there's a process where people, they start the process and they get what's called a priority date, and that kind of puts them in line for when they get their visa. And so often it takes many, many years to complete the process and actually get your green card. Okay, so here is kind of a chart that just shows each step of the process. So you've got up here at the top, we've got, the person's in non-immigrant status. So for example, on an H-1B worker visa, if they're in the EB2 or EB3 category, they're going to have to go through this perm labor certification process with the Department of Labor. And that's broken into three subparts. So first there's prevailing wage request. And that's where it's determined what is the kind of standard prevailing wage that somebody in this position is being paid in the location where they are working in the US. So that process takes about 3 to 4 months. Then there's a recruitment period, and that's when the job is posted in the local newspaper, on the company's website, and they recruit for the job to see if there are any minimally qualified US workers for that position. And that can take like 60 to 90 days. And then finally, the perm application is filed. And currently that's taking about 16 months. So a long process. It's not something that's going to be quick. Unfortunately, it's not that, an employer says, I found somebody who I want to help and we're willing to hire them and can we sponsor them? It's not going to be like that. It's not going to be, okay, they're able to start working in a month or two or even several years. It's a long process. So once the perm is certified, then the I-140 petition is filed, or this would be the first step for any of those EB1 categories. And then once approved, then the person can seek to adjust status within the United States. There are situations where you can file the I-140 and the 485 at the same time. And that's if there are visas available for the category at issue when you're filing. So to explain that a little bit more, I'm going to talk really quickly. So I'm just keeping an eye on my time about the visa bulletin. And this is just the process by which everybody tracks kind of where people fall in that line while they're waiting for their visa. So as you can see here in the EB1 category, for most folks, so anybody who's not from one of these identified countries, it says that it has a C, which means that visas are current. So that means somebody who is seeking that category, they don't have to wait. They can file the I-140, and if it's approved, they can seek the green card. They can file the 485. Same thing for EB2s for everybody except for these some of these identified countries. But you can see that for some of them, there's a pretty big backlog. So like for EB3, people who are from India, they are just now having visas available in that category for people from India who started the process in 2013. So it was quite a while ago, and it just does take some time. Okay, Anna, are we getting close on time? I don't want to. I'll go through these last few things really, really quickly. So some new developments in business immigration. The travel bans are a big one. I know Amanda talks about that. We're also seeing an uptick in visa revocations, and that's the process by which the Department of State revokes somebody's visa when they're in the United States. And all that means that when they travel abroad next, they're going to have to go to the consulate and get a new one, which they might not get approved for. So we're seeing more of that. There's also enhanced vetting. Social media reviews is a big thing right now. So for a lot of non-immigrant categories, the government is requiring applicants to set their social media accounts to public, and then those are reviewed as part of the application process. So important for people to be aware of that and to be cognizant of what you're posting on social media. I'm sure you guys have heard in the news, there's also increased enforcement efforts, and that's kind of across the board. So we're seeing that by the Department of Labor as part of the PERM process. We're seeing that by USCIS for the applications and petitions that they're adjudicating. You know, they might show up at an employer's work site and ask to review their records and confirm that the employees who are supposed to be working, the foreign national employees that they sponsored are where they're supposed to be and doing the job they're supposed to be doing. And then also more I-9 audits and other types of enforcement actions like that. One thing I did want to make sure to touch on is the elimination of automatic extensions of work authorization. This is a big deal for employers and foreign national workers who are working pursuant to an employment authorization document. And that's because previously, if somebody was working with an EAD and they filed to extend it, they automatically got an extension while the application was pending, the renewal application was pending. So that's since been eliminated. And so it's just really important for employees working on EADs and their employers to be aware of that and make sure that people are filing very early to renew so that they don't have those gaps in work authorization. Because if they do, the employer is going to have to either terminate them because they're not allowed to employ them or place them on like a non-paid status, but it just can create some issues. And then finally, there's been a number of changes to the H-1B process. Really, really quickly, there was a new weighted lottery rule that just went into effect this first lottery that we just did in March. And the practical implications of that change are that the anticipated, I think, goal of the change was to have more senior, higher paid jobs have a better chance of getting selected in the lottery. There's also that 100,000 H-1B fee I mentioned, which is being litigated. It only applies in certain circumstances, but it is a pretty significant fee. So something that obviously employers are taking note of and being mindful of. And then we also anticipate that there's going to be an increase in wage rates. So I'm just going to blow through these last a few because I wanted to hit on this last slide really quickly. For anybody who is working with foreign national employees, I would say just encourage them to always carry proof of their status with them, whatever that may be. So their green card, their passport, their I-94, their EAD, they need to have it with them so that if somebody stops and asks them to prove their status, they can do that. I already mentioned the social media, and then just a reminder that foreign nationals also have to keep the government informed of their addresses. So anybody who's in like a non-immigrant status, they do have to, if they move, they have to update the government. And that's important to make sure that you get all mail that may come to you that is really important to your status. So sorry, I went through that really, really fast at the end. And I think we just have a couple minutes, so I'll give it back to you, Vanna.
Okay, well, Molly, thank you so much. We just had a few questions and it looks like they were answered. The first one was about the Einstein visa, and you definitely went over that. Uh, let's see, said when you talked about the EB1. And then the next question was, can you change in H1B to EB1 or EB2? And you just answered that in your last slide with the fee. So we got through all the questions.
Great.
So if there are any others, I know that the presenters left their information, so please feel free to reach out to them. The only other question we had was about the slides. We will try to make those available. Otherwise, our presentation today will be available on Legal Services YouTube page. So you just go to youtube.com and search for Legal Services, and we'll make that available soon. Other than that, thanks for joining us today. If this topic or any other area covered by legal service interests you, please consider volunteering your time, talent, and treasure to Legal Services Volunteer Lawyers Program. More information on that can be found at lsem.org/volunteer. A special thanks to our speakers, Amanda Williams, Mollie Hennessee, my co-chair, Katie Crispin, the Young Friends Board, and Louisa Gregory, and all LSEM staff who helped make today CLE a reality. Thanks so much for your time. You all enjoy the rest of your day. Bye.
Take care.
Thank you.